Howdy, and let's move on to another video on Chapter 2. Following your book, the essence of Chapter 2 is on how litigation is conducted. And what we want to get out this on relative to data breaches is some additional information. Remember in Chapter 1, we talk about the FTC as the leading regulatory agency for data security. And then in Chapter 1 also, there's a reference of NIST and U.S. CERT. I have published a couple of videos this week. We'll talk about them on the controls and everything. Okay, so FTC is the leading regulatory agency, but now we're going to talk about standing to file a lawsuit. Now, you can sue the FTC, but the FTC can bring actions against you according to their rules. For you to sue someone or for you to participate in a lawsuit, you must have standing. And standing is the three basic elements. You must have suffered injury in fact, and these are legal terms. It has to be concrete and particularized, and it must be actual or imminent, not conjectural or hypothetical. Let me give you an example relative to cybersecurity. Many say that you have to have, if you're the victim of data breach, actual damage. You must fulfill this prong. Other corporate courts have interpreted as saying actual damage can be just the threat of your identity being stolen. So you have to have actual imminent injury, not something, well, I think it may get stolen. And so you actually have a split in the circuits with some saying you have to have your data stolen to fulfill this prong, and others say just the threat you can have your data stolen is actual injury. You must be able to trace that injury to the defendant's unlawful conduct. Okay, again, another problem in cybersecurity. You get your identity stolen, but you don't know where it happened. How do you go back and know who to sue? And even if you think you know, trace it to that defendant's unlawful conduct. The third is it must be redressable. So you must have an injury in fact. It must be traceable and redressable, meaning it can be fixed. Okay? And when you have standing, the courts have said you must clearly and specifically set forth facts sufficient to satisfy the standing requirement. Okay? So in your initial pleading, you claim to have standing, and you will tell the court in clearly and specific language why you have standing. Your injury, it's going to be concrete and particularized. Give it to me in words. It's going to have to be actual or imminent. I can trace it to defendants, and it's redressable. Now, I don't have to do this beyond a reasonable doubt. I just have to do this sufficient enough to satisfy the standing requirement. Also, keep in mind Article 3, standing is a constitutional right. Your right to file lawsuits. So, here's where there's a split in the circuits. Do data breach victims automatically have Article 3 standing? Well, it depends. Nothing's really automatic. But if you go back through these elements, some courts say actual means you have had to have had it stolen. Others say the threat of having it stolen is actual injury. You have to be able to trace it, and you have to be able to redress it. Now, our elements of what we currently come with standing comes from a 1990 case, Whitmore versus Arkansas. I find this an interesting case because it's a U.S. Supreme Court case, and it's a death row penalty case. So it doesn't matter, because what it's giving us is the elements of standing. It's establishing the current law in the process for determining whether you have standing or not. It could be, if you look in the footnotes, clean air and water, one on the line item veto, one on Endangered Species Act. And basically it says who can sue. This is an interesting case because Arkansas does not have an automatic mandatory appellate review of death penalty cases. Most states, if you are sentenced to death, will have an automatic appellate review. Now, remember where I told you that at the district court level, you look at the facts and you have to have a mistaken law to go to the appellate. But in death penalty cases, they say, oh, you don't have to prove a mistake in law. We are going to have a mandatory appellate review before we actually impose death. Arkansas did not have that. Mr. Whitmore was not the party in this particular execution. It was another gentleman who had killed a few people and said, hey, it doesn't have a required mandatory appellate review, and I don't want a review. Go on and execute me. Whitmore was another inmate on death row, so he filed in the first inmate's case against Arkansas, and he claimed, first of all, that the 8th and 14th Amendments require mandatory appellate review, and the court found no. And also, but what was also came out of this case was the elements for standing, and they basically said this guy lacks standing. He cannot file a case as what's sometimes called the next friend, or a close associate that can file and claim standing without a prior relationship. He didn't know this guy. He was grasping at straws. He was trying to delay his own death penalty. There was a similar priest or minister who was administering to this death row inmate. He tried. The court said no. So our elements of standing come from this case. It established the elements for standing. Now, I want to take a minute. The book doesn't say anything, but we talk about the amendments in the Bill of Rights. I've put in red which ones you'll see in cybersecurity quite a bit. And let's go to our little chart here. You'll see sometimes in cybersecurity or cyber cases, someone denied freedom of the press or freedom of speech or something like this online. You'll see a lot of the Fourth Amendment here. This is the Fourth Amendment. We'll have some lectures on the Fourth Amendment. And it, if you click on this, will show you the actual amendment. All right. What it's about and what it's stated in the Constitution. So if you're not familiar with these, you might want to spend some time. Let's see, what are some others I said? Due process, freedom from self-incrimination, double jeopardy is the Fifth Amendment. So I have to have due process. I am not forced in this country to admit to a crime. I claim the Fifth Amendment. And if I am found not guilty of a crime, I cannot be tried again, which is double jeopardy. And sometimes you'll see Sixth Amendment, right to speedy trial. Now, here's the thing. There turns out those are the first 10 amendments, and those are our Bill of Rights. We have 27 amendments currently in the Constitution. All right, so I brought this up from Wikipedia. Now, go back a minute. Let's see, which one was... if you look here, the Fifth Amendment gives us due process. Now, if you look here, the 14th Amendment gives us due process. Okay, I'm confused. If we had the Fifth Amendment as due process, why do we need the 14th Amendment to also define due process? And here is why. The first 10 amendments were voted on with the Constitution of the United States when our country was formed. All the others were amended. The Constitution was amended by the process of amending. You can look here in 74, 1803, all the way up. And the Fifth Amendment at that time was referring to the federal government. After the Civil War, we passed the 13th, 14th, and 15th Amendments. 13th abolished slavery and involuntary servitude. 14th defined citizenship. Define certain things. We won't talk about that much except the due process clause. And it's about citizens' rights, and being able to get the due process means that you're going to have protection against someone just coming in, accusing you of crime, finding you guilty, throwing you in jail, or something like that. It applies only against the states, but it's identical to the Fifth Amendment, okay? And both clauses have been interpreted to encompass identical doctrines of procedural and substantive due process, and you can read that here. It's that the person has protected interests in life, liberty, or property, and there has to be a procedural way to interfere with that person's life, liberty, or property. And substantive is that the fundamental rights of citizens will not be encroached on by government. So they're the very same. One's the federal, one's the state. And so that's the answer to the question, why do we need two amendments? But here's where it's important for what we are going to talk about in cybersecurity. Due process deals with the administration of justice. So it's a safeguard against arbitrary denial, something that would interfere with your life, liberty, or property by the government. Okay, that ends video 2, and we'll move on to video 3. Thank you.